Welcome back to the 2011-2012 Medical Dental Legal Update, a 20-hour program on medical malpractice, risk management, healthcare law, practice management, and selected clinical topics. The following presentation, Structuring Your Practice, Part 2, Retirement Plans and Insurance Captives, features David B. Mandell, JD, MBA. Mr. Mandell of Fort Lauderdale, Florida, is an attorney and a principal of the financial consulting firm Odell, Jarvis and Mandell, LLC, where he specializes in risk management, asset protection, and financial planning. He has authored a number of books, including The Doctor's Wealth Protection Guide, endorsed by 5 state medical societies. Mr. Mandell is a frequent national speaker, and his articles have appeared in more than 100 publications, including over 30 medical specialty journals. You may contact Mr. Mandell with your questions and comments at 877-656-4362 or by email at mandell@ojmgroup.com.
Hi, this is David Mandell. I'm one of the principals of the OJM Group, consulting firm with over 1,000 physician clients across the country. We're now going to continue in the second hour of my presentation. As you recall, in the first hour we covered in depth corporate structure for medical practices, including how to protect the key assets of a medical practice, such as accounts receivable and real estate. We also looked at buy-sell agreements and why they're so important for medical practices. And finally, we discussed a bit why physicians with otherwise smart advisors often get suboptimal advice, the importance of coordination and other key factors there. So let's build on that and continue our agenda. And in this hour, we're going to look at qualified retirement plans, other types of benefit plans. We're going to drill down into one specific plan that I think makes a lot of sense. I'll speak a little bit how that relates to what we were talking about in the first hour and the importance of corporate structure. Then we're going to speak on the topic of captive insurance companies. And this is something that I've seen more and more information out there about and more physicians asking me about than ever before. And I've been working with captives since 1997. So we'll then conclude and wrap up. Qualified retirement plans. Let's talk about those for a number of minutes here. I assume, or I would guess, that if I were in live with you and I asked a number of you how many of you had a qualified retirement plan, probably all of you would, especially if I include IRAs in that definition. Now, technically, IRAs are not qualified retirement plans. They're technically called custodial accounts. You don't have a legal entity technically like you do with a qualified retirement plan. And what are qualified retirement plans? They are pension plans, profit-sharing plans, 401ks, for physicians inside of a larger institution like an educational institution or a large hospital. You might also have a 403b. All of those plans, 401ks, 403bs, profit-sharing plans, pension plans, defined benefit plans, are all under the category of qualified retirement plans. IRAs, traditional deductible IRAs, not Roth IRAs, but traditional deductible IRAs, are similar in that you get a deduction up front and the assets grow tax-free. We'll talk about that in a minute. So for our purposes today, we'll talk about qualified retirement plans. And if you have a SEP IRA or what's called a deductible IRA, then that is also covered under a lot of my comments here. Now, with qualified plans, there are some significant benefits to the physician participant and some significant drawbacks. And let's take a look at those one by one. On the benefit side, one thing that is true in all states, so all of you, no matter where you live in the U.S., qualified retirement plans are protected at the highest level from lawsuits. Meaning if someone sues you, and you have funds in your qualified retirement plan, under federal law, U.S. federal law, that is protected. That's an important benefit. Okay? Also, probably the benefit we all like the best is that you get a tax deduction for the contribution. Technically your practice does, or whatever the employer is, gets a deduction for the contribution, and you as the participant don't pay any tax when those dollars go in. So you can defer income that goes into that plan. And those two things are really the two key benefits. Probably as you participate in one, you don't think as much about the asset protection, probably think more about the tax benefit, and that's certainly important. Now, if we start to think about the negatives to a qualified plan, and we really dive into those as we will now, you start to see how in our firm we have reservations about qualified plans. It's not as if we recommend all of our clients not to have one. In fact, I'd say of our 1,000 clients, most do and still contribute. But you still, just like any medicine you would prescribe to a patient, you want to make sure clients understand the benefits and the detriments, the pros and the cons, because there are side effects. And let's take a look at the side effects of a qualified retirement plan. The first one is you have to cover all of your eligible employees. Now, we're certainly a firm that advises our clients that having benefits for employees is important. We're not here to give as little as possible because the cost of turnover is significant. The value of having good employees stay is significant to the practice. So it's important to provide a competitive benefit package to employees. But still, as we talked about in the first hour, you have to think of yourself as the CEO of the practice. And as the CEO, as the owner of the practice, you want to look at your qualified retirement plan and understand what is quantifiably the amount of cost you have to put in for employees so that you can participate at a level you want. And as we'll talk about in the next slide, we see a lot of physicians who are not maximized on that scale, meaning they're either putting more into for the employees than they need to given their level of participation, or that they could put in more for themselves given the level of employee participation. And you just want to understand where you are on that spectrum. The second bullet here in terms of the negatives is really the most important. I'll cover the next two as well, but this one is really important. Full taxation on withdrawal. Okay, in a couple of slides, we're going to look at the history of the U.S. federal income tax. I think you'll find it very interesting. But for now, let's understand the point here that the way these work, qualified retirement plans, SEP IRAs, is you get a deduction for the contribution and no tax on the way in. You get tax-free growth during the growth within the plan. And then when you take dollars out, presumably in retirement, you're going to pay the ordinary income tax at the time that you are retired, okay, when you take the dollars out. Now, for a lot of mass media out there, and for most taxpayers across the country, remember from the first hour that half of the U.S. households do not pay federal income tax. Okay? So you have to understand when you get mass media and you get a lot of noise out there from whether it be CNBC or various magazines and newspapers. And we get into this point very much in depth in our book, which again you can get a free copy of. But the point is there's a lot of information out there that says maximize how much you put in qualified plans, no matter what. And the assumptions behind that is a couple. Is one, for most people out there, they're employees. And so when they put dollars into the plan, it may be matched, maybe a 401k match or something like that from their employer. So absolutely, they should be taking advantage as employees of putting dollars into that kind of plan if they can get free money from their employer. And if some of you are in that position, that's certainly a consideration. But many of you may be on the ownership side too, meaning you're the owner and the dollars that are matched are coming out of your pocket. So it's a different consideration, your participation. That's why you have to understand the employee costs, and we'll talk a little bit more about that in a minute. But on the tax side, what's really important here is essentially the way it works, you're getting a deduction today, you're paying tax when you take dollars out. So what does that mean? That means you're foregoing the income tax today in exchange for whatever the tax rates are when you pull the dollars out in retirement. Again, for most Americans, they're going to be at a lower tax rate in retirement, lower standard of living, because they're actually going to have less income in retirement. They're going to lower their standard of living and have less income. For a lot of our physician clients, by definition, they're going to try to work until they can get to a place where their retirement is at the same or close to level of income as they are today. Okay? And so, in fact, if you look at the tax brackets, even if you're not at the highest bracket, which today is at 35% federally, or you're at the second bracket, you're still above 30%. So it's not a big difference between the top and the next level, the next brackets there. So for most physicians, most of you listening, when you get to retirement, most of you will be in close to, if not the highest marginal rate. So what that means is you're exchanging today no tax by putting dollars in the qualified plan in exchange for whatever the rates are in the future. And if you're going to be at one of the highest marginal rates, which you likely are in retirement, you're really making the bet. You're saying, I won't pay tax today because I believe the top rate or top two rates will be lower in the future than they are today. Now, we'll look at the federal tax chart of the history in another slide or two. But understand that's your bet. And maybe a lot of you sitting and watching this right now say, hey, that doesn't sound like a great bet. I think tax rates are going to rise in the future. And if you do, realize you may think that. I think tax rates are going to go up in the future. But if you're contributing to a qualified plan, you're making a bet against that. Because if you truly believe that rates were going to be much higher in the future, you'd pay the tax today, not use the qualified plan, and invest after tax. Now again, I have a qualified retirement plan. I haven't contributed to the last couple of years, but we're not in the position that says qualified plans don't make sense, but they should be hedged with something else, and that's going to be a benefit plan I'm going to talk about in a minute. The key is to realize what it means when you contribute to a qualified plan. The other two negatives to a qualified plan, I won't spend much time on, but they're important to realize. One is, for some reason, Congress has decided that 59 and a half is an age which you can retire, and 70 and a half is an age by which you must take money out of the plan. So what that means is, in a qualified retirement plan, if you take dollars out, with a couple of exceptions, before 59 and a half, you're going to pay, in addition to the income taxes, a penalty on that. Don't ask me why Congress came up with 59 and a half, but that is the rule. Same thing on 70 and a half, you're going to have what are called minimum required distributions. So you're going to have to take dollars out there and pay the tax there. So in terms of flexibility, in terms of access to dollars, whether you want to retire early or maybe draw dollars on late, this is not a good type of plan for that. We'll talk about another plan that is better for that. The other thing is, if you're going to be in an estate taxable situation where you pay a federal estate tax when you pass away, dollars in the qualified plan are the worst place to have money, because not only is that going to be part of your taxable estate for estate tax purposes, which now rise between 35 and 50%, and those rates may go up higher, but also income taxes need to be paid. So if federal estate taxes are in the 30s to 40% and income taxes in the 30%, and you have perhaps state estate taxes and state income taxes, which most people will have, you can easily lose 75% of what's in your qualified retirement plan to taxes when you pass away without proper planning. So the deduction going in is good. That's why we all like the qualified plan. The asset protection is great. That's why we all like the qualified plan. But costs for employees, the bet on taxes going down in the future is a poor one, I think. And you have to realize it's a bad place for flexibility and it's a bad place for estate planning. That's what you have to understand about qualified plans. Now, given that, you might think, God, Dave and his firm might be completely against qualified plans or advise against them. Again, most of our physician clients have qualified retirement plans. We like the deduction today. We like the asset protection. But the key there is to maximize what you can do, meaning if you're going to have a qualified retirement plan, you might as well make it as efficient as possible. I think we would all agree on that. And really, what the key to that is, as we see on the slide here, is the 2006 Pension Protection Act. What a lot of people don't realize is that act by Congress actually set some new rules, some new formulas in place. And if you haven't reviewed your qualified plan in the last 5 years in a real in-depth way, you may be missing out on opportunities. Again, opportunities to be more efficient, to put more dollars in versus vis-a-vis what you put in for employees, or to put in the same amount you're putting in now, but be able to scale down what it costs for employees. I've had lots of physicians come to me and to our firm and say, I stopped a qualified plan a number of years ago because it just got too expensive for the employees. Or We're reviewing our qualified plan, to look at the investments, but we haven't really dug into the formulas to understand, could we do better? And the opportunity is there, especially if you haven't looked into it for the last 5 years. But we regularly see clients with qualified plans that are underfunded. Now, again, this is another area where it's so important to get specific advice. I'm speaking here on qualified retirement plans. I know a fair amount about them, but I'm not an expert in qualified retirement plans. I don't do that all day, every day. And neither would your CPA, neither would your attorney. You need to work with somebody who just knows qualified plans. Now, in our firm, we happen to have somebody like that, who spent 20 years at Morgan Stanley and Fidelity and all that, just looking at qualified plans. And that's who we have in our process that works like that. Find somebody like that who understands qualified plans and can look at it from an independent nature, not the investment person. The person who's running your investments inside of your pension for your practice or for the firm, for the organization, they've got a vested interest in the structure as long as it keeps sending them the investment dollars. You want someone who can look at the structure itself to maximize it. I use here an example of a combination plan, we call a combo plan. This is a plan that has both defined benefit elements and defined contribution elements. So two different formulas, two different ways Congress and the tax code look at the plan. You can combine them into basically one plan that has both elements. And we've seen physicians, owners being able to put in well over $100,000 a year in that type of plan, whereas before they were only using one element of the plan, and maybe their contribution level was maxed out at $49,000 or $50,000 in that neighborhood. They were actually able to double, or in some cases we have $150,000, even triple what they were able to put away before with a similar or slightly larger contribution for employees, but the ratio was much stronger. So the key thing is to understand, you're going to have a qualified plan, understand what the pros and cons of it are. You're going to continue what you've got, make sure it's as efficient as possible. Now let's look at the tax chart here. Very interesting. This is a chart of the highest marginal federal rate under the US tax code every 10 years. So I don't have every data point for the entire period here, which is nearly 100 years. We're almost at 100 years of the US income tax being implemented. I don't think there'll be any big birthday parties for the income tax, but we're almost at 100 years. So what this shows you is every 10 years what the marginal rate is. Certainly you can go out and do your own research, get on Google, take you probably 2 minutes to Google up the specifics. But this gives you the exact message and picture that I'm looking for. If you look at this chart, what you'll see is for most of the 20th century, certainly after World War II through 1980, for the 40s, 50s, 60s, 70s, and 70s, stopping with 1980, the marginal highest rates under the federal tax, not even putting into consideration state taxes, but under the federal tax was well above 60%. In fact, for some of these decades, the highest rates were above 80%. So, I know that there's a lot of talk that we may go back to 39.6 as the highest rate, which was the rate in the 1990s. And there was a lot of discussion. Now, again, that is on pace under present law to happen January 1st, 2013. It was put off by the compromise of Congress and the President in December of 2010. So it didn't take place in 11, it's planning for 13. But going from 35 to 39.6 is a significant jump, certainly for taxpayers who have to pay that extra tax, but it's nothing like what we've had for most of the 20th century. And again, this is not political. If you look at those years, and as a US history major, I'll test myself right now, 1940s was FDR and Truman, who were Democrats, and 1950s was Eisenhower, who was Republican, 1960 was Kennedy and Johnson, who were Democrats, and then into Nixon for 2 terms, who was Republican, and Ford Republican, and then Carter Democrat. So you have lots of different presidents and different political parties. I mean, really kind of an even match between Republican and Democrat, yet you still had those high rates. Now, those high rates don't translate exactly into where we are today because you used to be able to write off a lot back then. You could write off credit card interest, and you could write off a lot of passive losses against active income. So a lot of physicians back in those days would invest in different real estate partnerships and other things where they would get lost and that could go against their active income as a physician. You don't see that today. So I don't think rates will ever get that high. It wouldn't be apples to apples. But I do think if you look at this chart, it's hard to come away and realize that in 2011, 2012, we're at the third lowest federal tax position we've ever been, and that includes the lowest in the Depression. I think other than that, there's only one time when we were lower at all over the last almost 100 years. If you understand that, and what I was talking about in the first hour with most taxpayers paying federal income tax, or close to half, and then the largest taxpayers, the multinationals, not paying a federal tax. Between those two things, I think as physicians, as high earners who are individuals, it becomes imperative to realize that the bet of your qualified retirement plan, that tax rates will be the same or lower in the future, to me is a bit misinformed. It doesn't mean we shouldn't use qualified retirement plans. The asset protection is terrific. But it does mean you have to understand that tool, make it as efficient as possible, realize the bet, realize the history of the taxes and where we may go, and then maybe conclude that another plan should be implemented at the practice along with the qualified plan that hedges a bit, that doesn't bet that tax rates go down, that in fact actually gets more valuable as tax rates go up. Let's talk about that for a minute. So I mentioned here on the slide how many of you have a benefit plan under Section 79 of the tax code. Just like 401k is the number in the tax code that governs that type of plan, a Section 79 plan, not too creative, is governed under Section 79 of the tax code. And the key to this, to understand this plan, let's talk for a minute about qualified plans, non-qualified plans, fringe benefit plans. Technically, under the tax code, this plan, Section 79 plan, is under the fringe benefit section of the code. And if you're interested, certainly you can contact us. There's a brochure that the IRS puts out themselves, Department of Treasury, on fringe benefit plans, and there's 2 or 3 pages on this plan. So it's been in the tax code for, I think, over 40 years. And we'll talk about that in a second. But many of you physicians may be there and say, you know, I trained or I grew up and went to college with some other bright guys or bright women, and they didn't go to medical school. They made a different choice. They decided to be executives at large companies. And they seem to have a lot of benefits that I can't do in my medical practice, and that's frustrating. A lot of docs come to us and they say that. Say, isn't there something else I can do just other than my 401k or my qualified retirement plan? And when you think about large corporations, they really have 2 ways to compensate their executives other than the qualified plan. For them, qualified plans are almost meaningless because the amount of dollars that can go into it are so restricted. In many 401ks, it's $14,000 or $16,000. That's not going to make a big impact on your friends and colleagues and family members, perhaps, who are executives at large companies. So what can they do? Well, the first thing they do that we can't do, and I say we, when I was practicing law, we couldn't do it at the law firm, which is stock options. Stock options in a law practice, because only lawyers can own it, not going to be valuable because you can't go out and sell it on the marketplace, go public, as they say. And same thing with a medical practice, restricted in who can own it. And so you can't use stock options in a medical practice. Can't get wealthy that way. Well, what's the other type of plan? If you look at most executives, and this is all public information, any public company, you can dig into their annual report and you can find out how many dollars are going into Google or GE or whoever company you want to look at, their executives into their non-qualified deferred compensation plan. And in a non-qualified deferred compensation plan, what happens is this: the dollars go into the plan, but there is no deduction to the company. Okay? Now, that's fine when it's Google, because Google, we all own shares in there. Okay? And so that tax deduction, maybe they do it for the top 500 executives, maybe it would be $5 million or even $50 million. But it's not a significant number on their multi-billion-dollar per quarter income. So one, it's not significant, but even if it were, they're not the ones stuck paying the tax bill, because when the dollars go in, there's no deduction. Obviously, the taxes are higher because it wasn't a deductible expense, but we all as owners share in that. We all get a piece of that because the dividend may be less, et cetera. So one is it doesn't matter, but for us it does matter because we have closely held practices, right? That's, we're the owners in addition to the executives. So that doesn't make a lot of sense for us. What if there were a plan that acted like a non-qualified plan, but it were at least partially deductible to the practice. The other big benefit to the non-qualified plan for the executives at those companies is it's unlimited in how much they can put in away. So where you might only get $14,000, $16,000 in your 401k, your brother who works over at GE might be able to get $200,000, $300,000 into the non-qualified deferred comp plan every year because there aren't those kinds of restrictions. And they only offer it to the executives. The rank and file of the 50,000, 100,000 employees don't have access to that. That's what non-qualified deferred comp is. But the key there is they don't care about the deduction. You and I do. So what can we do about that? This plan, under Section 79, I like to think of, I call it two things. One, I call it a hybrid plan because it has elements of a non-qualified plan that you would get at a Fortune 100 company, which in terms of the limitations are much higher, how much you can put away. And the tax treatment is not like a qualified plan. It is more like a non-qualified plan. We'll talk about that in a second. And it has elements of a qualified plan. So let's dig down into that, okay? First of all, in many states, the asset protection in a Section 79 plan is at the highest level it can be. So it's just as good as a qualified plan in many states, okay? Probably about 20 states throughout the country. The physicians in those states, when the money goes into that plan, they own it themselves, and it's totally protected from lawsuits. In the states where we don't have that rule in their state, the flexibility of this plan allows them to own that asset in the plan in a trust or perhaps in a limited liability company, which provides some level of protection. So in all states, you can have some level of protection, and in many states, you can have the highest level. The key, one of the key factors here is this. The amount of contribution that can go into this type of plan is significantly higher than a qualified retirement plan, and in some cases, depending on the formula, can be $200,000, $300,000 or more. We have physicians putting in, I know, clients at least $200,000 and sometimes even more than that into this plan. Because it's not a qualified retirement plan, the formulas that I mentioned before in the Pension Protection Act, which are so important and govern qualified retirement plans, are irrelevant here. There's some different formulas that have come out in a revenue procedure by the IRS, but those formulas can allow much larger contributions than the qualified retirement plan. So if you're sitting there saying, God, I'd like to have some more dollars grow for me for my retirement and have it be asset protected and get some tax benefit out of it, this might be a good plan for you. The other key factor is that this can be done in addition to your qualified retirement plan, like 401k, profit sharing plan, pension, etc. So as I was talking before about the onerous taxation, in my view, of qualified retirement plans, because you're trading today's tax rates for future tax rates, and I think future tax rates are going to be higher. The choice isn't either or. You can do both. That's really an important point, is that the clients who have this plan, including myself, I have this plan, can do this in addition to their qualified plan, because it's not another qualified plan, it's a fringe benefit plan governed on a different area of the tax code. So for the physicians who say, I want to keep my qualified plan in place, the employees like it, maybe I'll put in less for myself, because I do agree that it may be a bad bet tax-wise. I can have this plan in addition, and they're totally unaffected by this plan and the qualified retirement plan. If you're in a group practice, which imagine many of you are, this next point is probably the most important for this plan, is that the physicians can vary how much they want to participate in this plan. So we literally have clients, Dr. Smith, Dr. Jones, and Dr. Mandell. Dr. Smith decides this plan is really important, a part of his long-term planning. He totally agrees that tax rates in the future are going to go higher, so he wants to put this in place to hedge against that. He can put $100,000 a year into this plan, again, in addition to the 401k. Dr. Jones says, you know what, I just got divorced or building a second home, cash flow is really tight right now, it just doesn't make sense for me, I'm going to put $0 in this plan. And then Dr. Mandell can say, well, you know, I'm kind of in the middle, I have the cash flow to do something, I do agree on the taxes, I'm going to put $30,000 a year into this plan. Assuming the facts work out and their formulas work out, they can do that. Okay? Certainly, the ability for one doctor to say, I don't want to participate, or I want to participate at a level of $100 a year, some minimal amount in the definition, they can do that. And so we have lots of clients. I can think of one in the Northeast, urology practice, 4 physicians. One doc's been participating in this plan for 3 years. The other physicians haven't participated. They've waived out. And it's completely allowable. The other point that I don't have on the slide, but it's important to mention, is that the employee costs are extremely low for this type of plan in most situations. Again, you have to sit down with a benefit plan expert and look at your practice. But the rules are so much different than a qualified retirement plan, and because you're offering this in addition as a fringe benefit plan, if you have a large practice, you may be able to carve out a group of 10. That may be just the physicians, so a group of 10 physicians, or 8 physicians and 2 executives, office managers. But you don't have to offer it to all the rank and file. If you're less than 10 employees total, including the physicians, you probably do, but the cost can be extremely low for the employees. And the only way to look at that is to sit down and have the numbers run on the plan. So the way that the taxes work on this type of plan is the corporation gets 100% deduction, just like your 401k. Okay? The difference is on your 401k and qualified plan, you don't pay any taxes when the dollars go in. Okay? It grows tax-free, as we talked about. You pay the taxes when you take it out, so you're hedging, so you're at risk to rates going up higher in the future. This plan, the corporation gets 100% deduction going in. You pay tax today, but under the formulas, most physicians will pay tax on about 60% of the contribution. It might vary, and it depends. You have to look at it specifically for you. But let's just use 60% as an example. So let's use 100,000. 100,000 would go into this plan from the practice, 100% deduction to the practice. 60,000 is the amount I'm taxed on that goes in for me. I pay tax on that. Let's say my tax rate is 40%, federal and state. So I'll pay tax of $24,000, but yet the whole 100 has gone in and is growing for me. So in the future, what happens? Well, the assets grow tax-free, and I can pull the money out tax-free in retirement. So think about that for a second. You pay tax on 60% or so going in, get tax-free growth and tax-free access. That's a perfect hedge to your qualified plan where you're paying no tax up front, but you're going to pay tax on the back end. As tax rates go up, your qualified plan is actually worth less every time tax rates go up. This plan is unaffected by future tax rates. Many of you have probably heard of the term and the tool called a Roth IRA. In the last couple of years, the rules have allowed high-income taxpayers, like physicians, to take advantage of Roth IRAs. And a lot of clients, including some of our own, have converted their qualified plans or IRAs into Roth IRAs. Well, when you convert to a Roth IRA, what do? You pay tax on the entire amount that goes into the Roth, then it grows tax-free. You can have access to it tax-free in the future. Why would someone do that? They would do that because they want to pay tax today and avoid rates going up in the future. That's the whole idea around Roth IRAs. So if you've heard about a Roth, you've considered a Roth, or you've used a Roth, then you understand that that is really, again, a bet that tax rates are going up in the future, and a way to hedge against that risk. But remember, in a Roth IRA, you pay tax on 100% of the dollars that go in. Now let's look at this fringe benefit plan. Here, you pay tax on about, again, depends on specifics, 60% of what goes in, and you still get that tax-free growth and tax-free access. So in some ways, you could say it's a Roth IRA on steroids, right? Now, again, technically different part of the code, et cetera, fringe benefit plan, different. But if you're thinking about it, what is it going to do for me? What are the benefits? The benefits are you're getting partial tax deduction going in, unlike the Roth, but you're getting the benefit of the Roth. You're getting, in many states, the top asset protection of the qualified plan without subjecting yourself to future income taxes. And you can do both, and you can give yourself a lot more flexibility. You may want to do this, your partner may not. That can be done. So it's a tremendous hedge against future income and capital gains tax increases. It's a tremendous plan in terms of flexibility. The 59.5 and 70.5 rules I just talked about with qualified retirement plans do not apply here. So if you're someone who's really funding your retirement and a real saver, and you say, I'd really like to start pulling dollars out when I'm 55, not 60 or 65, this is the plan for that, because with the qualified plan, you're probably going to pay a penalty. So for a lot of my clients, including myself, we have both plans in place. And that way, if for some reason I'm wrong and in the future, 20, 30 years from now when you're in retirement, that tax rates are actually very low, then a qualified plan turned out to be the right bet. But if it turns out tax rates are much higher, the 79 plan is the right bet. And in fact, unlike our parents' and grandparents' generation, people retired at 65 and passed away at 70 to 72, many people in our generation, and many of you watching this, are going to be retiring maybe in your 60s, but may, hopefully, live very healthy lives until your late 80s or 90s. That's a 30-year potential retirement horizon. There's a lot of tax changes that can happen over that time. And to just bet on one tool and limit your retirement and your benefit planning to qualified retirement plans, and not use fringe benefit plans or hybrid plans, however you want to call it, as part of your planning, to me is a real mistake. And it's one of those things that your brother, sister, colleague who's gone to the corporate world is not making that mistake. They're very conscious and very focused on these other types of planning mechanisms. And you need to also, as the CEO of your practice. Now, if you look at this last slide on the hybrid benefit plan, you'll see that it can tie to estate planning, et cetera, but also that the IRS rules are very clear. So a lot of clients will say, man, it sounds great, it sounds like a terrific plan, but is it really legitimate? Can I get in trouble for that? And what I tell them is the same thing as a 401k. 401k is in the tax code, been there for decades. This plan's been in the tax code for decades. Just to show you how our federal government works, this plan's been in the tax code for, as I'm saying, 30, 40 years. That's what Congress creates to create the tax code. The IRS is supposed to not make law, they're not supposed to make the tax rules, supposed to interpret them and give us regulations. And so while this tax law has been in place for decades, it wasn't until 2005 that the IRS finally came out with what are called safe harbor rules for this type of plan. It was in a particular revenue procedure in 2005. So that shows you how long things take. Sometimes it takes decades for the IRS to get around to defining the rules for a plan that's been in place. So for our firm, once we had those final safe harbor rules in 2005, we can feel very comfortable advising clients to put this in place, put it in place for ourselves. And the TPA, the third-party administrator that actually administers these firms for our clients, is the largest in the country and has had, I think, just because they have thousands and thousands of participants, about 25 or 30 of them audited in the last couple of years, and none of them have had any change. And so I think it done right, it's just like a 401k. Can a 401k be screwed up? Absolutely. You can put in too much for the owners versus the employees. You can have embezzlement, you can have mismanagement of the funds. A lot of things you can do in a 401k to mess it up, with this plan as well. But if you're doing a conservative approach to your 401k, you'll have no problem. If you're doing a conservative approach to this plan and following the safe harbor rules that the IRS has set out, you will have no problem. So that's really important to understand. It's very black and white. It can be done right. But look what's in the slide at the bottom, in capitalizations. Very important. What do I have written there in that slide? Only for C corporations. Why is that so important? Let's think about what we learned about in the first hour of my talk. The choice of entity. What are you going to choose in terms of an S corp or a C corp or a disregarded entity or proprietorship or partnership? This helps you make that decision, meaning that, like I was making the point, why good physicians, smart physicians with good advisors don't get the right advice. Unless you are knowledgeable of this type of fringe benefit plan, until the experts in my firm educated me on this, I practiced law for 15 years, never even heard of this plan. Why? Because the tax code of the US is the largest set of rules created by humankind. You can't know everything that's in the tax code. This plan's been sitting there, and since 2005, it's been well defined by the IRS. Yet, you can only use it if you're a C corporation. Now, unless you're one of the very, very few physicians in the audience who looked at all the different types of benefit plans, figured out which ones made sense for you, and then worked backwards to determine what type of entity you should have, or entities, multiple, for your practice, good for you. You're one of the very, very few. Most clients chose an entity just because accountant recommended it, they came into the practice, that's the way it's always been. Okay? I use my brother as an example. He trained in New York, moved down to South Florida as a cardiologist, joined someone, worked there for a couple of years, didn't work out as a partnership. He left, it didn't work out to be partners, it was a corporation, to be technical. And in that month that he left, he was thinking about, I need to find space. Can I recruit the old patients? How am I going to make a living? I need to get a new Medicare number. All the things he was thinking about, the last thing he was thinking about is, when I start to really make money in this practice, what's the best corporate structure for me? No, he called the accountant and said, I need an entity, set it up, I need to find a place, I need to get a lease, et cetera, et cetera. Now that he's 5 years into that practice, reviewing, saying, hey, is this really the best structure for me? Now it makes sense. So I don't blame anyone when they come to us not understanding or not having a good handle on why they are what they are. But unless you've drilled down and used the same approach you would use in medicine, when you treat patients, you don't just randomly quickly choose a treatment plan or a medicine. You think about all the different options, or when you're diagnosing, you rule things out. Say, I'm going to look at that, rule it out. Take that test, rule it out, rule it out. Narrow it down to your diagnosis. That's science. Are you applying that same rigor to your corporate structure? Have you looked at all these different benefit plans? This 79 plan is just one. This may sound very attractive to you, and likely it is. But if you've already chosen the most popular way to become a medical practice, which is an S-Corp, then you've ruled this out. You can't use this unless you change your practice or add another entity to it. So big picture here is, not only are these entities so important for helping you save taxes today, hedge against future tax increases, help you protect assets, be more financially efficient, get more out of your practice, but it makes an extremely important impact on your corporate structure. That's why when physicians come to us and they say, hey, I want to save taxes, and certainly a lot of clients want to do that. And we even have an engagement where we won't charge a fee if we can't show at least a 200% return on our fee in tax savings. So that's something you should certainly contact us about. But when a client says, I want to save taxes, we always insist that we are engaged. Even if the goal is tax planning, that we look at three different things. Taxes, so we'll look at the returns, the CPAs in our practice. We'll look at corporate structure and benefit plans. Because in our view, you can't get, as a physician in practice, the right tax advice without having experts on corporate structure, tax, and benefit plans. If you don't have all those three heads together, and believe me, they're smarter than me, three heads make better than one, especially from three different disciplines all working for the same goal. That's what you need to do. Again, whether it's our firm or you can put together three advisors who all look at it in three different ways and coordinate that on your own, you need to do that. That's why benefit planning and corporate structure tie so closely into tax planning together. So as a conclusion on this, do you know why you employ your existing qualified retirement plan? What it is, why you use it, et cetera. Has it been reviewed under the new, now 5 years old, but relatively new Pension Act and what's come on after that? Would you like to enjoy tax savings and retirement planning beyond that? Do you think, ask yourself the question, get educated, do you think tax rates are going to go up in the long term or down in the long term? And is your retirement planning reflecting that attitude? Can you hedge against it? Can you put yourself in a better position that way? And if it does it make sense to review these benefit plans and be open perhaps even to a change in corporate structure? And for a lot of physicians out there, it does make sense. So I want to continue now with another topic that has tremendous tax benefits, tremendous asset protection benefits, probably the most powerful tool I've seen, and I've been working with these tools called captive insurance companies since 1997. But I can tell you, I've never seen the amount of interest and activity in the physician marketplace on captives that I've seen in the last 12 months. I think it's because people are finally realizing the opportunity for asset protection, wealth creation, even tax benefits with this tool called captives. And more practitioners out there. I think there's a lot you probably want to stay away from. You want to work with the firms that have been doing this for a long time. But a lot of physicians who've never heard of captives other than reading our books and our materials on it are coming out of the woodworking and asking me, saying, hey, someone just came to our practice to talk about captives. What do you think about that? What do you know about that? Is this something that's a good tool? So I want to make sure we address that because probably a number of you have already heard about captives. Some of you may have implemented, and I think a lot more of you, now that you are aware of the topic, are going to see that put in front of you over the next year or two. So what does a captive mean? A captive in a physician context means a small insurance company under our tax code that insures primarily just the practice. So it's really about you owning your own insurance company. Now it's a very small one, and it's one that primarily and only insures the practice. There may be some other third-party insurance that has some limited stop loss, and there's some technical rules for that we won't get to today. But the primary insured is the medical practice. What kinds of risks might that insure? A lot of physicians will ask me that. Well, if we have a captive, I already have medical malpractice insurance, so what do I need other insurance for my captive for? Believe me, we'll talk about in a slide or two, we'll make a list of different types of policies. But the firms we work with, the actuaries, the law firms, the insurance managers, they have tens and tens and tens of policies that they've done for medical practices around the country that they can retailer for your practice that have a host of different risks. Let me suggest a couple. Certainly you have medical malpractice insurance, but there's limits to that coverage. What about losses in excess of that coverage? You could have an excess policy from your captive. What about the exclusions? Every policy, the reason an insurance policy is 20 pages thick is not because it covers everything, because it has exclusions. So they can look at your exclusions and say, well, we're going to step in there. What about deductibles? Your insurance policy is going to have deductibles. The captive can stop in there. Then what about a whole host of risks you have no insurance for? Employee claims. The practice gets sued for sexual harassment or wrongful termination. What about economic type claims? Claims that your leading reimbursements go down, or claims that you have a licensure issue, or a audit from one of your managed care carriers or insurance companies. All of those things are risks you probably have today, and there's a host of others, we could spend an hour just examining that you don't have insurance for. And you hope you don't have it, and if you do, you'll pay up at that point. Well, that's called self-insuring, and guess what? You get no asset protection for that, you get no tax benefit for that. So if you're self-insuring on any of those types of risks, and I'm sure you have, if you really examined it with a good actuary and insurance manager, a lot of those, you could create a captive to insure those risks. Now, one of the reasons you would do that is to protect the assets, because if the money is growing in a properly structured captive, that's going to be very well protected against lawsuits against you, against the practice. Taxes is a significant benefit too. Here on this slide, we talk about what's called 831B. Again, it's another tax section of the code that governs small insurance companies. And that section has been in the code since 1986, and the precursors of that section go way back until, I think, the 1920s and 30s. So there's been, for decades now, laws in the books that provide these kinds of tax benefits to small insurance companies. Essentially, Congress wants to encourage firms like yours to create small insurance companies, because every once in a while, a bunch of farmers get together and they create State Farm insurance, and they create farmers insurance. Small companies eventually do turn into medium companies, into large companies. And so there have been tax rules on the books for years to encourage the creation and management of small insurance companies. In fact, there are thousands of them in operation. Bush, before President Obama, made some changes to the laws that actually made it better. And the IRS itself is coming out with what we call private letter rulings every quarter that gives us more and more guidance on how to do a captive and how to create them in a proper way. And many of them actually have to do with physicians. So in a diagram form, a captive essentially, and this is providing insurance coverage to the physician, to the medical group, and the practice is paying for those insurance premiums, just like it would pay from any other insurance carrier. Just like any other insurance carrier, if those premiums are reasonable, they are deductible to the practice. And what 831B says is if you have the properly structured small insurance company, that company is actually tax exempt on the income. And the limit of that is $1.2 million per year. So you literally could have a business or a medical practice paying $1 million for different coverages. And again, the key is those coverages being reasonable, the policies being reasonable, and that's where the actuaries and insurance managers are so important. But $1 million getting deducted from the practice and going to the captive, and the captive not paying any tax on that $1 million. That's the real power of the small insurance company tax rules. And so if you can have the risk management, and you have the risk to manage, which I'm sure you would, and you have the need for asset protection, and you're interested in putting another profitable center of your practice, like a building, that can be part of the practice that you can retire on, that you can have new physicians buy into. A captive can be a tremendous tool for the overall planning at the practice, and that those tax benefits make it extremely attractive. There aren't many other opportunities in the tax code to essentially have a tax-exempt entity that you own, and that's for profit, and the small insurance company rules do allow that. So here's a slide with the different types of policies. I don't want to dive into that too much because basically any medical practice, $3 to $5 million of revenue or larger, is going to have the types of risks that could justify a captive insurance company. So another reason to sit down with an expert and understand, is this a tool that works for me? Certainly they exist. Certainly many medical practices take advantage of it. The question is, does it work for my practice? What are the types of policies? Would it be deductible? And what if any, is a benefit that our practice could take out of a captive? So we see here the key roles at our firm. We're a consulting firm. We advise clients on a lot of this. We may recommend captives. We don't create and manage captives. The real important players in the creation and management of captives are the law firms, CPA firms, the insurance managers, the actuaries. And again, we work with firms that, for our clients, set them only up domestically. There are a lot of states that have gotten into the captive business. That's another reason you may hear about it. So Vermont, Montana, Kentucky, Alabama, South Carolina, all of these states Hawaii have introduced over the last couple of years, or in some cases many years, captive legislation. They want to get captive business. So this can all be structured in the U.S. tax compliant. But the key are those types of firms. And since I've been working in this field since 1997, I really know who the right players are. So we've probably narrowed down the list of firms we work with across the country. There are hundreds. There's probably 2 or 3, maybe 4 that we'll work with, and we have confidence to refer our clients to. So to conclude on small captives, does your practice have these types of litigation, economic, employee, and other types of risks? And the answer is they do. I know because I've worked with thousands of medical practices. But the key is, does it work for you? Does it make sense? And are you a practice in a position to take advantage of it? You want a minimum size, probably $3 up to $5 million in a revenue, not profit, revenue of practice to really look into in a serious way captives. Now there are some firms that are very adept at creating captives for a number of different practices or joining a group captive. And so if you're really interested in this and have a smaller practice and you're interested in talking about a captive, you definitely should contact us because I could do another lecture on group captives and ways to take advantage of that even in a smaller practice. So make sure you make a note of that, and if that's something you're interested in, certainly to contact us. So now let's put this all together. If you look at this slide, there's a lot of topics we covered in the last 2 hours, but there are lots we didn't. Tremendous amount of factors that go into making a medical practice financially, tax, legally efficient. We covered some really important ones in the last 2 hours. Corporate structure, benefit planning, tax, asset protection. But there are a whole host of others that go beyond this. And that's why a multidisciplinary team is so important. I'm very proud of the fact that at our firm, we've combined experts like attorneys, CPAs, PhDs, MBAs, certified financial planners, qualified plan experts, fringe benefit experts, money managers, all in one house. But we're not the only firm out there that does this. Certainly there are others that have put a number of the elements together. They may or may not specialize in working with physicians. You may take on that role yourself and try to be the quarterback and coordinate and make sure you're getting the right advice from the attorney and the CPA and the qualified plan and the money manager and the insurance advisor and the CFP. But is that really your highest and best use? Would you rather be seeing patients, running the practice, and then spending time with family or in your personal life? So for a lot of our clients, they're looking for a quarterback. I encourage you to find one, whether it's our firm or another, because your highest and best use is practicing medicine and then spending the time as you want to. So as I wrap up with next steps, first of all, as I mentioned at the outset of the first lecture, as a gift, as a benefit, as being part of the AEI attendees, we are willing to provide our latest book, whether it be the National for Doctors Only or one of the state books, to you for free. So please feel free to contact us. Let us know you're part of the AEI seminar series. I've got my phone number up there on the slide, as well as my email. Personally, you can contact me. If you'd rather, you can go direct to AEI and let them know I want to get a copy of Mandell's book, and we'll make sure we get that out to you. The key is education, learning. You're a physician, you went to school for a long time, you want to be educated. That's why you attend CME seminars. The book is a good place to start. We have at our firm free newsletters. We have webinars twice a month. They're always free. And the key is to learn more. So hopefully this is the beginning of that education. I look forward to speaking to any of you who want. Feel free to contact me at the information there, or get a hold of AEI with questions about this lecture, about getting a free copy of the book, or anything else in these fields. I look forward to talking to you personally. Thank you.
That concludes another in a continuing series of programs on medical malpractice, risk management, healthcare law, practice management, and selected clinical topics. Presenting was attorney David B. Mandell.